Moving on now to the big story that we are tracking, the big development that took place in the Supreme Court in the hijab case and the split verdict, which has become a topic of discussion, also invoking several political reactions across the country. The ban on hijab in classroom stays, at least for now. The debate between right to choose or regression will continue a bit longer. Now, just like Times Now told you, today the Supreme Court two-judge bench differed on whether Karnataka's hijab ban should stay or go. In a split verdict, the judges agreed on a divergence of opinion and recommended that the Chief Justice of India set up a three-judge bench to decide on the ban. Till then, status quo will remain, which means till the larger bench decides, there will be no hijab in classrooms. But where have the judges differed, and what is the thin line between choice and uniformity? Times Now does a deep dive into the order and does a complete dissection of the verdict. Backing the ban, Justice Gupta in the past too has said that hijab is not an essential practice. However, Justice Dhulia contends that it's a matter of choice for a girl child. So here on Times Now, we are dissecting the entire order. It's a split verdict. Justice Gupta, in fact, has backed the ban on hijab in the classrooms. But on the other hand, Justice Dhulia said he's more concerned about the education as far as these young girls are concerned. And there is a difference of opinion within the society, within the political class as well. Several responses come in from political parties. Now, let's play out some reactions that we got right after the split verdict was out.
Benefit of having read the judgments yet, Justice Gupta seems to have framed 11 questions of constitutional law that he felt arose in this case. He did not give the reasoning and said that we have answered it against the appellants. That Justice Dhulia, on the other hand, said that he felt that this is not an issue of essentiality, and the High Court misguided itself by going into the question of essentiality of religion, and said this was actually a question of right to education of the girl child. This was a question of freedom of expression of the girl child. This is a question of right under Article 25(1) and not of essentiality. And he said that the question that he asked himself and that he has chosen to answer is, are we making the life of the girl child in India any easier? The appeals had to be allowed, and the judgment of the High Court and the order of the Karnataka High Court had to be set aside. The matter is still pending in the Supreme Court. We hope that an appropriate bench will be constituted at the earliest. Hope for an early resolution and justice.
So Justice Dhulia has spoken about this being a matter of choice, while Justice Gupta has debunked the entire choice argument. Let's go across to Meghna, my colleague, who's joining us with more details of the order in detail. Yes, Meghna.
Absolutely, Swati. In fact, here on Times Now, we have dissected the entire verdict to get you clause by clause, point by point, contention by contention as to what the justices have said in their order copy. This is a detail of what they have said, and this is what has been said by Justice Gupta. Justice Gupta has upheld uniformity. He has said that the state has the jurisdiction to ensure uniform as per the College Development Committee. Goes on to say equality before law is to treat all citizens equally, irrespective of the caste, of their creed, of their sex. Also, he says that such equality cannot be breached by the state on the basis of religious faith of anyone or their sex or gender. Constitution allows the state to regulate economic, political as well as financial aspects of the religion as well. So they have every right. He also invokes positive secularism, citing the full bench of the Punjab and Haryana High Court in Gurdain Kaur versus the state of Punjab, in which he says, we're going to press a continue on that and show you what it says. It says that the unshorn hair is one of the most important and fundamental tenets of Sikhism, because that was the parallel which was drawn. Goes on to say on the right to free speech and expression that rights are subject to reasonable restrictions and have to be read in conjunction with each other. It cannot stand by itself. It goes on to say, as per the executive powers, the Karnataka government order is not an unreasonable restriction which has been put by the government. Also reminds that religion is a private affair and has no meaning in a secular school which is run by the state. This regarding the right to free speech and expression. Now remember, there were those who said that hijab provides dignity. On this, he says that the argument of hijab adding dignity not pertinent to the students attending an all-girls college, as was the case in the Karnataka High Court. That is the objective. He says it doesn't amount to denial of right to education if a student chose not to attend school and can instead choose to go to a school which does permit a hijab. He talks about the state funding as well. This is very crucial as well. that essential religious practice is not relevant to institute maintained wholly by the state funds. Again, this is something that Judge Gupta has put out in the order copy. He says it is open to the students to carry their faith in a school which permits them to wear hijab. If you don't want to wear it, don't go to a state funded school, go to another school where it permits you to put your religious dress on display, is the contention. He then says students have no right to be in school in violation of the uniform which is mandated by the rules of the school and the committee, which remember has the principal as well. So let's also tell you what is the other voice, the other dissenting voice. This is coming in from Justice Dhulia. Justice Dhulia is someone who has upheld what he calls wearing a hijab as a right to choose. In fact, on essential practices, he says, under our constitution, wearing a hijab should be simply a matter of choice. Question of essential religious practices is not at all relevant in this entire dispute. He goes on to then say that it may not be essential but simply a religious practice, a matter of faith or even conscience, or a faith in this consciousness and dignity. He says when it comes to denying education to girls, he says that the fallout of the hijab restriction would be that we would deny education to the girl child. Are we making the life of a girl better by denying her education because of her hijab? So essentially saying you deny her the right to wear a hijab, you're denying her education. He says it harms no one else. If the belief harms no one else, then there should be no justifiable reason for trying to ban the hijab. He goes on to say that the order in Bijo Emmanuel case is the guiding star which will show us the path which is laid down ahead of us constitutionally. This is the path of understanding and tolerance, and is also called as reasonable accommodation. He also then goes on to say, and this is very significant because it was said that this is about dignity of a woman, that discipline cannot be at the cost of freedom and it cannot be at the cost of dignity of this girl child. What is more important, education of a girl child or enforcement of a dress code by the state government? He talks about it, saying that she retains her fundamental rights to dignity and of privacy. Even when she is in a classroom, it doesn't stop at the gates of the school, but it is even beyond that. A girl child carries her right to dignity and choice, is what Justice Dhulia has said. He goes on to say that democracy is based on trust, and trust minorities have reposed upon the majority. This is the trust he's talking about. It's time to foster sensitivity, empathy, understanding towards different religions, and that the state's order goes against fraternity and human dignity, liberty, equality and fraternity. So this is essentially the contentions which have been made by Justice Dhulia. As you can see, Swati, an in-depth understanding of the two judges show this divergent view, whether it is choice or whether it is regression.
Right, the divergent views in fact has led to now the larger bench taking up the entire matter. Meghna, thank you for getting us those details. Let's open this up and go across to our guests. We're joined by Dr. Subramanian Swamy, former MP. We also have Zakia Soman, women's rights activist, and Majid Haidri on the broadcast. Let's begin with Dr. Swamy. Dr. Swamy, what this means now, the split verdict, is that the legal battle will go on. How do you look at the developments today?
Well, this has happened many times. I'm not, after all, we won in the High Court in Karnataka. Now it's come before two-judge bench, and there was a split. Now they can have 3 or 5, depending on the importance of the issues raised by the two judges. So I don't think it's like a cricket match where you have first a victory and then a draw, and then again you go for the finals. Where you have a choice to make sure you can win. I think personally, given everything, this is a case where we should win, because it's a very reasonable thing according to my understanding. All we are saying is that when you are in school and there is a uniform, you can't wear hijab. Now that's not any loss, it's a reasonable restriction. When you come to the school, up to the gate, you can wear hijab and come. When you're in the school, you take it away. And when you leave the school again, as you leave the gate of the school, you put on the hijab. So in the public eye, you are wearing hijab. It's only inside the school you are not wearing hijab. Like inside a house, in your own home, you will not find children wearing hijab. And there are movements around the world, for example in Iran, where women say, no, we don't want hijab. You see, so it's not a un-Islamic thing. There can't be a more hardline Islamic country than Iran. But 584 people have been killed demonstrating that we will not wear hijab. You see, do the Muslims of India say anything? Maybe they think they are all Shia Muslims, so the Sunni Muslims who are in great majority in India, they may feel no sympathy for them. But women want some elbow room. And in the school, the children should not be made to feel awkward that I am different from the others. They should be for example, the school will not allow satin salwar kameez or satin skirts or whatever. They will say all the cloth will be from a particular shop and it will be of the same quality. So that is why the hijab, it was not directed at hijab. It was directed at the fact that we wanted uniformity. And all this rubbish talk, some may come with tika, some come with Mangal Sutra. How can schoolgirls come with Mangal Sutra? Only a married woman can come with Mangal Sutra. So I think the conservative wing of the Muslims, they are just finding themselves losing ground. Okay. And they are afraid that the day the Muslims also start looking like Hindus, maybe all the Muslims will become Hindus. That must be the fear.
What do you think of the impact is going to be of Justice Dhulia's observations on the Karnataka High Court, upholding the ban on hijab when the matter is taken up before the Chief Justice of India?
No, because they know it's a divided thing. And therefore there will be an appeal. I mean, not an appeal. There will be it will be placed before a larger bench. In fact, it was a mistake to place it before two judges, because two judges sometimes deadlocks do take place. So now it will go before a 3-judge bench or a 5-judge bench. So I think it has no effect whatsoever on the Karnataka judgment. That still stands till the Supreme Court has a definitive judgment.
Right. Now, there are multiple reactions, multiple political reactions as well on the split verdict. Leader of the AIMIM has termed Justice Dhulia's observations to be secular, but Justice Gupta's observations to be hardliner. How do you respond to that?
Well, these are accusations. Why should I dignify it by remarking, you see? Justice Gupta is highly regarded in our circles. And I don't think that he is biased in favor of any one religion or the other. After he has taken the oath, he's been very fair, and so it's no use targeting him like this.
How do you see the split verdict, Dr. Swamy, in line with some of the observations that were made by the Karnataka High Court, upholding certain restrictions upon freedom of choice?
Always freedom of choice is subject to restrictions. There's no such thing as unfettered freedom of expression, freedom of anything, you see. The fundamental rights are all subject to reasonable restrictions. They are in the Constitution. And we have, otherwise anybody can talk anything. But we say, no, you can't. And if you do, then there will be a defamation case against you. So if you, on the other hand, you cannot express religious feelings which offend other people. And if you do, then there will be a hate speech case against you. So, I mean, therefore, we are very clear. You have freedom, speak, but don't cross the line. And the line is that don't try to take away the freedoms of other people by speaking in a certain manner. I mean, that is the key thing, and one must learn by reading the Constitution.
Right. Now, Dr. Swamy, the issue and the important aspect of the girl child's education came up during the observations amidst the pro and anti-hijab episode. And what is your take on that?
Yeah, well, I haven't seen anything objectionable in that. I just do believe that at least for Hindus, girl education is like Saraswati's doing puja to Saraswati. Saraswati is the goddess of education, and therefore I don't think that there is any ban on any girls' education as far as Hindus are concerned, and I would assume that the Muslims who want to live in India would live by this constitutional principle that we are all equal. Otherwise, why would you ban triple talaq? Because it is anti-woman. And similarly, there are other aspects where we don't want women to suffer any disadvantages. We have amended our Hindu code law. We have on dowry. So many things we have done. And I think it should be clearly understood that women and men differ only on physical strength. But now it's not an age of physical strength, it's now an age of the brain. And therefore men and women are equal. And in fact, if you look at the competitive exams, you find women are coming more first than boys.
Right.
Girls are coming first more than boys.
Dr. Swamy, thank you very much for giving us your time and for taking those questions. Let me take that across to our other guests as well. Zakia Soman and Majid Hydri continue to be with us. Zakia Soman, your first response to the split verdict and in fact the reactions coming in, and I would say some irresponsible statements being made by political leaders as well of, one particular verdict being a hardliners view and the other one being secular.
So in a way, the split verdict signifies the split opinion on this hugely controversial and politicized issue. I believe right from day one, this issue should have been resolved within the educational institution through dialogue, through discussion between the college authorities and the parents and the girls. Unfortunately, it became absolutely politicized and went out of hand, and the matter reached court. I'm very clear that hijab is not mandatory in Islam. It is a patriarchal imposition. But at the same time, how fair it is to deny girls their right to education just because they are in hijab. So it is outright discriminatory to not allow entry to girls into classroom because they choose to wear the hijab. So this imbroglio was sought to be resolved by the Supreme Court verdict. But unfortunately, that has not happened. I'm sure a larger bench...
Other constitutional questions and other constitutional issues have cropped up during the entire argument. I want to bring in Majid Hydri as well. Zakia Soman made an important observation. She said it's not intrinsic to Islam. It's more like a matter of choice, Majid Hydri. What do you have to say about that?
Well, Swati, firstly, happy Chauth and more forward to Nari Shakti. See, this is not a split verdict of equal proportions. It's more in favor of the Muslim community, and tell you how. Justice Dhulia has raised an important point of Bisoi Emanuel case of 1987, which brings a total twist to the story. So now this case will have to be reconsidered in the light of that Bisoi Emanuel case. And second point, Justice Gupta, who stood by the ban, himself has raised 11 questions, and 2 of them are most important for the government. He is asking that what about Article 19 and Article 25A? He is referring to the case of right to freedom of expression and right to religion. So when Justice Gupta is himself asking the government to come clear on that, I don't think that now it's going to be against the Muslim community which is standing for the case of hijab. Because we say, आप हिजाब में रहेंगे, सब औकात में रहेंगे. That is the basic point behind this.
और जो हिजाब नहीं पहनते वो औकात में नहीं रहते. What kind of a statement is that?
No, it's not about औकात में नहीं रहते. It's about औरत औकात में रहेगी, सब दुश्मन औरत हिजाब में रहेगी, सब दुश्मन औकात में रहेंगे. It is like that. It's not against women.
हाँ, तो औरतों पे आपने डाल दिया है. किसी और को लाइन में रखने का responsibility भी आपने औरतों पर डाल दिया, Majid Hydri. Anyways, I think there are a lot of constitutional issues and questions, like you said, which the larger bench will have to focus on. Thank you very much, Majid Hydri and Ms. Soman, for joining us on the broadcast.